Good afternoon. This is Sean Golding with Golding & Golding. We've presented a few different times about 3520 penalties and CP15 notice, but lately there has been an uptick in the number of people who are getting CP15 notices. There's a lot of misinformation online. So let's take a little bit of time and do a quick sort of CP15, 3520, what do you do if you get the notice, how to respond. So people who typically have to report a large foreign gift or inheritance will file a Form 3520. Sometimes it'll be someone who has to report ownership or certain transactions with a foreign trust or foreign trust distribution, but I'd say maybe 90% of the time when a CP15 notice comes out, it's because someone received a gift, right? Joe or Jane is in the U.S., they have a family member overseas, family member is a non-resident alien, they gave $700,000 to help Joe or Jane buy a home. They didn't know they had to report it. A few years later, they go to a new CPA. They learn they have to report. Okay. 3520 penalties are significant. Typically what happens is it's 5% value of the gift up to 25%, 5 months. And most people don't learn they were supposed to do it till, 1, 2, 3 years have passed. Not always, but usually seems to be the case. So what do you do when you get the CP15 notice? A CP15 notice is basically putting the taxpayer on notice that they have the penalty. And what happens is the taxpayer has to kind of decide what they want to do. Oftentimes, the best way to start out is by doing a protest letter. A protest letter is the taxpayer's opportunity to show reasonable cause and not willful neglect, that there was enough of facts and circumstances in the taxpayer's favor, to convince the IRS that, hey, yeah, it's being filed late, but maybe there's no unreported income, there's no FBAR FATCA, or if there is, maybe the taxpayer's already been filing that, and that there should be a penalty waiver, okay? If the taxpayer already submitted a reasonable cause letter when they did their initial late filing, then they may not have the opportunity to do it again. But it's concerning because oftentimes when the IRS receives the protest letter with a late 3520, no one reads it, right? The IRS is understaffed, especially coming off of COVID where agents have stacks of papers on their desk. It wouldn't be uncommon for an agent to just not review the reasonable cause letter. So, whether you should resubmit it or not, even if you submitted it initially, is something to consider. But that protest has a 30-day tight deadline. If you miss those 30 days, then you lose the opportunity to do the protest. Before doing the protest, assuming that it's timely, you want to consider your options, right? If the protest is successful, that's great. If the protest isn't successful, typically you either will go the collection appeals route or the collection due process route. Now, appeals is different than a due process hearing. A collection due process hearing is technically a type of appeal, but it operates a little differently. With an appeal, you will get a letter typically after the protest is rejected. You got 60 days to appeal. If you don't appeal within that time, you generally lose the right to an appeal, and then you would have to do collection due process anyway. If you're going to do the appeal, a few things to keep in mind is you don't get to go to tax court after if it doesn't work out in your favor. When you have an appeal, you don't go to a settlement officer, you go to an appeals officer. Oftentimes, they're not going to look at it as in depth as a settlement officer with a collection due process. Why? Because they know you can't go to tax court. If you do the appeal and you're not successful, typically your option is to pay the amount due and then challenge it in federal court, Court of Claims, District Court. For some taxpayers, they don't want to do the appeal. They don't want to limit themselves. So what will happen is if the protest is rejected, you just kind of got to sit around twiddling your thumbs until you get a certain letter that allows you to do a collection due process. You don't get to do it at the same time as an appeal. It's an end game strategy. You wouldn't pay the amount due, because if you pay that amount due, you'll never get a collection due process hearing because there's no collection. And interest is going to be accruing the whole time, and you have the opportunity to prepay interest, which you would get refunded if you win. But the problem is, if it gets misapplied by the agent, now they think you're kind of partially paying the amount due, and you won't get a collection due process hearing request either typically. The main forms you're waiting for is an LT11 or 1058. Most of the time, it's going to be a proposed final notice of levy, which still gives the taxpayer 30 days, and nothing has been on their record yet. Some taxpayers, unfortunately, they get an actual notice of federal taxing that's already been placed, which puts taxpayers in a very precarious position, because there's a lien automatically when it's assessed, but now the world's on notice of it, and so you're doing the collection due process hearing. You may be successful, you may get the lien removed, but having a lien on there may impact certain employment opportunities. It may impact if you're going to sell a home. It might put you in sort of a situation where it looks like you have to sell even if you don't, or even if you're not in that type of position. It's important to make these decisions beforehand so you know the strategy you want to take. Strategies change along the way, but it's important to have a good idea, have your ducks in a row. So the most important thing is, if you get the CP15 notice, you still want to do the protest within 30 days because it still leaves both avenues available. If you haven't been penalized yet and you want to get into compliance, there's various programs you can do. If you're willful, you would do the voluntary disclosure program. If you're non-willful, there's lots of programs available to you. There's the streamlined procedures, delinquency procedures, and reasonable cause. We got a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.